Okay, Tunde.
Yeah.
What's making us laugh this morning? Let me just give you context, okay?
Yeah, tell me.
Yeah, so everyone knows, by going through all the other videos that we've been in legal battle with our local council, right? Which we started by ourselves, but in the middle of the thing, we were ordered by a judge to get solicitors to go forward to trial. And we appointed one, everyone knows that, but we've not really officially named those solicitors. We've had to concentrate on fighting the remaining of the case and then winning it in April this year. We're now in July. The solicitors themselves, we've made several complaints to them. We've even taken them to SRA and legal ombudsman. But legal ombudsman, they're taking quite a long time to respond. SRA already came back to say, yes, they agree that we were misled and stuff, but they didn't think it was serious enough for serious misconduct enough to fine them. So as a result of that, all three individuals in that law firm that was involved in our case, they all left. From the solicitor to her direct manager and the practice manager who dealt with our initial complaint when they dropped our case last year. They all left the firm. And I mean, you did something wrong, that's why you've all ran. Fair enough. But the solicitor's firm does not get away with what they did because they took more than £10,000 from us for our case and did nothing. So that's what we've been asking them to give us back, and they didn't want to. Ombudsmen are the only ones who can, in terms of going through like other channels without going to court. SRA can fine firms and fine solicitors when they do wrong. And legal ombudsman can award you compensation and even award your costs back, which is what we wanted. But because we know that it's going to take a long time, we thought, no, let's start the process. And the process to get this solicitor's firm was for professional negligence. And there's a protocol for that. Before you go to court, there's a protocol that you must follow before you eventually go to court. And it's a 3-month window that you have to let the other side know, the professional, meaning the solicitors, know what they did, and then give them an opportunity to respond. And if you come to some arrangement, then you may not have to go to court. So we're at that right now. We did that recently. When I say recently, we wrote
Hi guys, how you doing?
Hey, yeah, we wrote our letter before claim in June 6th, giving them 14 days to respond to us, even though the protocol says 21 days, but we give them 14 days. And in fact, on the 14th day, they did respond. The solicitor's firm acknowledged our letter of claim on the 17th of June to say they confirmed everything in our email, which had the letter of claim, and said they're considering it. They'll get back to us. So, and we've not had anything since. We've not. We didn't hear anything. But then we thought, hold up, what are these guys doing? Morning. How are you? Yeah. So we thought to ourselves that, why are they taking so long to respond? I know there's a 3-month window, but as much as there's the protocol, you have to give them 3 months to respond. We have been emailing them since last year, September, with everything that we accused them what they did or didn't do wrong. I mean, so what they did wrong and what they did wrong. We've emailed them since September. They know every single thing from the dates and, pinpoint everything. So when you are writing your letter before claim on 6th of June 2025, you know by now that you know where this is going. We've been asking you for our money back through the complaints procedure, and you've not given it to us. So now you know where we're going. So giving you the letter of claim is not a new thing. You've been knowing about it since September of last year. So since we were not hearing from them again, we started tweeting them, like putting tweets on their tweets on X. And some of them was getting retweeted. So I guess that may have been causing problems. And all of a sudden, this was last week, Monday, which would have been what, 21st?
24th.
No, what was the 21st was when we first started tweeting. Yeah, I think so. Then by the 24th, we got an email from another solicitor's firm claiming they've been instructed, they've received our letter of claim by the specific solicitors that acted for us, and they have now been instructed to take it on, and they use the opportunity there in that letter to us to claim. Now, mind you, we know the pre-action protocol. We know.
We're litigating in person.
We're litigating in person. We know the protocol. But this solicitors firm, and what all solicitors firm, what all legal professions always make the mistake of, regular people, they always assume they're the only ones who know the law, know everything. So this solicitors firm is responding to us and saying, oh, by the way, I'm responding to your letter of claim from the 6th of June. And that, what did they say? Oh, we're now representing these people. Anything else, any correspondence, send it to us. And by the way, I just want to point out section 6 point, is it 6.1 or 6.2?
6.2.
6.2 of the pre-action protocol, that your letter of claim does not demonstrate, it doesn't fully comply. So therefore,
And 8.1.
and she's using 8.1 to let us know that, which 6.2 is that in your letter of claim, you must detail, give information to the professional, what it is that they've done, timelines, as much information just to help them understand that, oh yeah, I messed up, I gotta pay up. Or, no wait, I didn't mess up, I'm not paying anything. Morning. So, but yeah, that's 6.2 in the pre-action protocol for professional negligence. So she points out that we've not followed that, and then uses 8.1 to, and 8.1 in the pre-action protocol is that if a professional feels the litigant or the claimant has not provided all information, they must, within reasonable time, let the claimant know, meaning us. Now, remember that this solicitor that acted for us already responded to our letter of claim on the 17th of June. So this new firm wants to just pretend like they didn't, like their clients didn't respond to us. We are unrepresented party, by the way. They are the solicitors. You've appointed another solicitor. Both of you should know the pre-action protocol.
Yeah.
And their letter, 8.1 actually also states, their letter of response has to include the pre-action protocol guideline in their response to us, which our solicitors already messed up with. When there is acknowledged our claim, they didn't even, our letter of claim, they didn't even attach the pre-action protocol. They just said, oh, we're considering it, we'll be back. And they just went quiet for over a month.
Breaching the protocol.
So, and then the protocol does state, is it 8.1 as well? I think 8.1 that says letter of response. No, acknowledgement. Which one is acknowledgement again?
7.1.
7.1, yeah. Because as a professional, when you have to acknowledge, 7.1 of the pre-action protocol for professional negligence states, you must respond or acknowledge the letter of claim within 21 days. Now let's assume that this new solicitor now is claiming you're responding to our letter of claim of 6 June. You're responding to that in July 24th, 2025. 6 June 2025 is when we wrote that. If I'm correct, 21 days after 6 June will be 27th of June, right? You're supposed to respond by, but you didn't. So you already, as a professional, talking to not just unprofessionals, meaning us, we're not legally trained, we're not solicitors, and you couldn't even bother to do your part. You then respond to me 48 days. So effectively, you actually are responding 48 days after the letter of claim. So whilst you're trying to tell me about the toothpick in my eye, meanwhile you've got the Amazon forest in your eye, in one eye.
That shows you the caliber of solicitors and barristers these days. Poor things. The industry needs to be regulated so badly. They're the worst of the kind that would get justice for you these days. They don't follow the rules, they don't follow the protocol, they don't even follow the code of conduct that they sign up to. So whenever you get in solicitors, you have to be careful, because they're going to promise you they're going to do something for you, take all your money and then abandon you. So you have to be very careful with solicitors these days.
I mean, it was laughable when we received that letter from that solicitor's firm. And then we noticed that when they emailed us, it was just by email. They only had our email address. And we wondered, hold up. Okay, they are mentioning things that are in this letter of claim, but we've not officially received anything from the previous firm to say, oh, by the way, we've now moved this issue to this firm. They're going to act on it on our behalf. So you're breaching GDPR.
Breaching GDPR, SRA
Jesus.
code, breaching all kind of...
You're contacting me from nowhere, telling me you're acting on someone. How do I know you're acting on these people? Nobody has said nothing. So we fired back on that to say, where's your authority? I mean, honestly,
GDPR.
where's the authority that you have to act upon this solicitor's firm? They've gone quiet. Since Friday, we replied them. Friday just gone 25th. Back-to-back letters to the both of them to say, who are these people? They claim that they're acting for you. And also, where's your letter of authority? I want to see when this firm hired you. Talking about how we didn't follow our letter doesn't comply with 6.2. And then you telling me about 8.1 says that you have to let me know. You forgot that. We know how to read.
How are you?
Morning. I'm good, thanks.
Well.
You?
Yeah, have a good day.
See you. Bye-bye. Yeah, oh goodness me, I'm going to try and wrap this up quickly. Meanwhile, you're doing the wrong thing yourself. Like, you're not even writing me, you're not even complying with the rules, and you want to school me. You, who's writing me a letter, you're writing us a letter. These people, we're taking them on by ourselves, not solicitors, and you think that I would have skipped from step 1 to step 6. You think I wouldn't have read all the way the whole full pre-action protocol and know what I'm talking about before I wrote my email? And then you're trying to now play a game to say I didn't follow. Meanwhile, you two, if you're now only acknowledging my letter of claim to tell me that I didn't do it right, you think 48 days is reasonable for you to tell me that.
You've already breached it.
So anyway, you've breached it too. So now, and another thing, while we were responding, preparing because we did actually give them a more detailed response, but we're not buying that you've now got another 3 months, because that's what they wanted to do. They wanted to add another 3 months on top of whenever we send them back the details they're asking for.
Delay and deny.
And we said, no, as far as we're concerned, you have 54 days left, yeah? Because you've been knowing since 6th of June, so don't try and claim another 3 months from now, we're in July. So we responded, we gave them more detail. Even the same thing we gave to the original solicitors, we've given it back to them actually. We didn't respond to these new ones because we're still waiting for their response about whether they have the authority to act on them. So I guess they are in a dilemma. It's just funny because I really would wish that people, no matter your background or whatever, as long as you can read, because it's a privilege to be able to read. Honestly, people don't understand. Reading, people see as, oh, I've read this, but that is such a super privilege. Because from being able to read, you're going to be able to learn so much. You're going to be able to learn so much and keep it in your head and share it with other people. This is what we're trying to do. I think a lot of people over the years have been so fearful coming up against these companies or solicitors or organizations. Oh my God, they've got big lawyers, big firm. Sorry, no. If you can read, if you can write, you'll be okay. Just get rid of fear. Face them on. Study what it is that they've studied. It's not that hard, really. The 1 hour that you might spend more on social media every day, use that 1 hour to learn law. No one's saying go and do a law degree, but just know the law of any country that you reside. That's what's going to help you.
You know the Equality Act 2010,
Yeah.
Human Rights Act 1998, Unfair Contract Times 1977. Laws like that will help you to go by every day. The Traffic Act 2004, we need to learn all of that because all those laws control our lives. Yeah, you have to learn that Section 2, subsection 3 of the Local Government Act 1972 makes all local government corporations. So if they want to do anything for you or with you, they need a contract. They can't just tell you what to do. Section 79, subsection 2 of the Local Government Act 1988 says the liabilities of every inhabitant is the liability of the council. So the council has a law. Keep knowing the law.
Any council in this
law.
UK.
They know. They know it's in the law. England is ruled by the common law. It's still in existence. So don't be perplexed. Don't let people tell you that doesn't apply. It applies.
And they know it when you go to court. They know it because once you throw it at them, they know they have to. Especially the judges, they just look down on you like, how the hell did they know that? How
and
the
also,
hell, you know
the Civil Procedures Rule 1998. These are things that we need to know. If we're going to know TikTok, you're going to have to know this stuff as well. It's an all-rounder thing. So to make yourself, fortify yourself, to protect yourself, the law works if you really do know the law. It does work.
And then to end this video off, just to let you know, the other firm, whilst we're preparing our final response to them, which we sent to them yesterday, we were looking for case laws, because we take our time to research, and we're looking for case laws to buttress what we're saying in our letter. Case laws came up. You would not believe that this firm, that the solicitors that we are suing, the solicitors that they've gone and taken on, we found a case law where they are the perpetrators. It's so funny. Similarly to what we are suing this particular solicitor for. So you've already breached, in the High Court found you guys to be dishonest. Right. Yeah. So, oh wow. Hold on, I'll come and continue. I had to pause there because we heard like a very beautiful voice singing behind us. It's actually one of the ladies who takes care of the park, and she just let us know this is her last day. Oh my gosh, she's such a lovely lady. But we didn't realize that she could sing. She just showed us her Instagram page, which is called Nobel Prize?
Noble Prize.
Noble Prize. So N-O-B-L-E.
On Instagram.
Yeah.
Noble Prize. It's a good awful
so N.O-B-L-E Prize.
Singer.
Yeah.
She's ridiculous.
She's got a very good voice. So that's why I had to pause.
Fantastic singer.
Just to finish it off what I was saying. What was I saying? Yeah, the solicitor's firm, the one that's now taken on the case from our previous solicitors, are perpetrators themselves. Like, you cannot make this stuff up. They were actually gotten for the same thing that we're trying to get their client for.
2023.
In 2023. Oh, you can't make this stuff up. But yeah, so here, there's a bunch of kids, so let me not record. But yeah, so please watch the rest of the video, look out for more. And don't forget to share this, subscribe, like our videos, and share them to other people so they can learn, so they can be liberated, so they can be, they can feel empowered. Yeah, that's it, empowered. Have a great day. Bye. Bye.
Bye, guys.